Hello, I'm Jeff Hampton with the Hampton Law Firm. Welcome to our YouTube channel. Today I'm going to cover a subject that I get asked all the time. Jeff, how do I get my DWI case off my record? Now, today, if you'll wait around to the end of this video, I will also provide you a free ebook, The Ultimate Guide to Your DWI Defense in Texas. Now let's just jump right into the subject. People ask me all the time, number one, Jeff, how long does a DWI stay on my record? And is there anything I can do about getting it off my record? So I'm guessing if you're listening to me and you're watching this video and maybe you found us through Google or you know about our law firm, there's a good chance your DWI case has already been resolved. Okay, so I'm here to give you and basically provide you some guidance, be your guide here today to lead you through what you need to do in order to make sure you can get it off your record if you qualify. Now, here's the thing when we look at this. First of all, before we get into the two ways to get it off your record, please don't think this works like your credit report. There are so many people that I've talked to that have said, well, I'm not worried about it because, hey, this falls off my record after 7 years or 10 years, right? Who cares? No, that's not how it works. That might work with a bad debt that's out there, but it doesn't work for your DWI record, okay? So let's talk about the two ways to get something off your record. Number one is called the expunction. And then number two is called a non-disclosure. Now, when we identify how do I get a DWI case expunged from my criminal record, there's only two instances that will qualify you for an expunction for your DWI. Number one, you would have had to have received a not guilty verdict at a trial, okay? If you were found not guilty by a jury, you qualify for an expunction. Number two, your case would have needed to have been dismissed by the district attorney's office in order for you to be eligible for an expunction. Now, if you meet one of these two requirements, a not guilty verdict at a jury trial, you're immediately eligible for an expunction. If the district attorney's office dismissed your DWI charge, you have to wait at least 2 years for a misdemeanor and 3 years for a felony if it was dismissed, okay? Now, you say, well, that's not me. I resolved my case under some sort of plea agreement. Now we need to talk about a non-disclosure. Now, how do I get my DWI sealed from my record? Well, until recently, DWI cases were not even eligible to be able to be non-disclosed from your criminal record. In 2015, the Texas Government Code section 411.0731 and .0736, that actually passed the Texas legislature to provide a non-disclosure options for first-time offenders on DWI cases. And then in 2019, the Texas Government Code section 411.0726 also was added to cover deferred adjudication probations on DWI cases. Now listen to this. To be eligible to have your DWI case non-disclosed or sealed from your record, you must have been convicted for a DWI that was not classified as a DWI with a blood alcohol over 0.15, okay? I don't want to be too confusing here, but there's two types of misdemeanor DWIs. There's regular DWI, Class B misdemeanor. Then there is a Class A misdemeanor of DWI with a blood alcohol over 0.15. If you took a plea deal to an over 0.15, you're barred from consideration. You absolutely cannot get it sealed from your record, okay? Or you must have received a deferred adjudication for a DWI since 2019. That's what the law says. Now, here's what you have to meet. Here's some more conditions, okay? In order to be able to get this sealed from your record, number one, you must have successfully completed your sentence. Number two, you must have paid all your fines, your costs, and your restitution that was required. Number three, you must not have had any prior convictions or deferred adjudications for any crime other than a Class C ticket, okay? And number four, you must also show that it is in the interest of justice in order to have your request granted. Now, here's the one caveat. Let's say you're sitting there listening to me saying, okay, great, I qualify for all of these things. One last thing to consider. If the state of Texas is able to prove that your DWI involved a car accident where there was at least one other person involved, like let's say there's a passenger that was injured, or there was somebody there that actually was in the car with you, okay? If that is able to be proven by the state of Texas, then you would not be eligible for a non-disclosure. In fact, the car accident doesn't even have to involve any injuries or damages, just the presence of another person at the scene of the actual accident, including somebody in your car, okay? Well, there's a lot of weird rules here, but that's how the legislature put all this together. So here's the example I give. For instance, you're driving in a car, your DWI involved a one-car accident in which you were the only person in the car. You're eligible for a non-disclosure under that situation. But if your DWI involved just a minor accident, a very minor accident, but you had a passenger in your car, you're not. This seems very arbitrary to me, but that's what the law says. So it's very important. Now, the next question as we wrap this up here, the people ask me, how long do I have to wait? How long do I have to wait before I can file for this? So it really is going to depend on whether or not you had an ignition interlock in your vehicle. That's really one of the biggest issues. If you received a deferred adjudication probation on your qualifying DWI case, you must wait 2 years from the completion of your deferred adjudication, then you will be eligible for a non-disclosure. Now, if you received a straight probation, which means if you received a probation prior to 2019, okay? If you received a straight probation and you volunteered, very few people do this, you volunteered to sign up to have an ignition interlock device on your vehicle, then and had it for at least 6 months, then you're eligible 2 years after the completion of your sentence, after the completion of your probation. Now, people say, well, wait a minute, I didn't have that. What if I did a jail sentence? What if I spent time in jail on it? If you received a jail sentence, you must wait a period of 3 years if you complete it, as long as you complied with a condition of sentence requiring an ignition interlock for 6 months. So if you went to jail and you had an ignition interlock for 6 months, you have to wait 3 years. Finally, what if you did not have an ignition interlock at all? If you didn't have an ignition interlock at all, here's the hard part. You got to wait 5 years from the completion of your probation, okay? And I know this is so confusing. Many of you are reading this down on my page. I wanted to give you a video to also explain this from my website. Here's the deal. It's hard to navigate this process by yourself. If you would like assistance with making sure you can get your DWI case off of your criminal record, don't hesitate to contact the Hampton Law Firm at 817-877-5200. I promised you if you waited around to the end of this, I would also give you a free ebook, Your Ultimate Guide to DWI Defense in Texas. Click the link right down here below, and I'll be happy to email you over that free resource. And thank you for joining us here today. I hope this video helped you. I look forward to seeing you on our next video series.